All right, Sebastian, great to have you here tonight.
Thank you, Logan, for having me.
So welcome to Patent Pulse, our Sunday evening session. I wanted to talk to you a little bit about the Samsung v. Apple patent infringement case on the iPhone back in 2016.
Yep. Well, I'm very lucky. I'm in the technology sphere, with my emphasis being in patent law with high-tech industries.
Right.
And it was an interesting case. The iPhone had just come out in about 2008, and Samsung was really, behind. They felt this pressure to, get out in the consumer sphere for personal electronics and specifically smartphones. And they started to really look at, we need to catch up with Apple and with the iPhone.
Right.
And created their phone, what some might say as, and what the courts decided in the early 2010s, as an infringing, design patent. In fact, Apple sued Samsung for this design patent infringement. Actually, they sued for
three of them, right?
Yes.
There was three intellectual property protections. It was design patent, as you mentioned, which I think is what I want to discuss with you here because I know you have a lot of expertise in the area, but it was utility patent as well, and then trade dress was another intellectual property.
Absolutely. And so we saw this suit from Apple that really went to the courts for design patents. And that resulted in a found infringement case. The courts found that Samsung had infringed on three specific design patents that Apple had filed. And
so the fact that they infringed was no question about it. Samsung infringed.
No question about it. The courts found it that they infringed, and that was, kind of a pretty much unanimous thing in the courts. But then, what went to the Supreme Court was not whether Samsung had infringed upon Apple's design patents. In fact, what went to the Supreme Court, and what Samsung argued, was a very specific section of the U.S. Code, Section 289. Do you know about Section 289?
Yeah, I actually do have a little bit of expertise, or at least I did some research before inviting you on, of course, on what Section 289 really says about design patents, but I think it would be good for our viewers on the show who maybe aren't familiar with the types of patents that Apple is suing Samsung for, that being the utility patent that we mentioned and the design patent. And of course, other intellectual property protection was trade dress. So the utility patent, those are something that typically lasts about 20 years from the filing date, and they cover the processes, the manufacturing, and how the invention works, how it's made and how it works. Trade dress is another type of intellectual property protection that really designates the origin or the source of a product and distinguishes it from others in that same market. That is something that trademarks will do, but trade dress really focuses on the embellishing features, such as perfumes are a common example that's used for this. There's been some cases of different perfume companies, such as Calvin Klein, infringing on others perfume bottles for having their bottles shaped very similarly and confusing the customer with what they're buying. And then design patents are the ones we'll be focusing on, and that is the ornamental design of an invention.
Yes.
Right? Is that?
Yeah, that's absolutely correct. And Section 289, which is really what's at stake in this case, because we know that Samsung has infringed upon Apple with these design patents. And so the question is Section 289 has this statement about how we apportion, or really the word shouldn't be apportion, as some of the justices in the Supreme Court really dislike that word, but how we award damages from a design patent infringement. Do you, by chance, know what that
I think it would be worthwhile to read this verbatim of what Section 289 that you're talking about really says. So, U.S. Code, Section 289, additional remedy for infringement of design patent. That says that whoever during the term of a patent for a design without license of the owner applies the patented design or any colorable imitation thereof to any article of manufacture for the purpose of sale, or sells or exposes for sale any article of manufacture to which such design or colorable imitation has been applied, shall be liable to the owner to the extent of his total profit, but not less than $250 recoverable in any United States District Court having jurisdiction of the parties. Nothing in this section shall prevent, lessen, or impeach any other remedy which an owner of an infringed patent has under the provisions of this title, but he shall not twice recover the profit, made from the infringement.
So, do you mind rereading? There's one particular section. It says the total profit. And
I think that's really what this case hones in on in this, in section 289. So rereading that one section says, to any article of manufacture for the purpose of sale or, exposes for sale any article of manufacture to which such design or colorable imitation has been applied shall be liable to the owner to the extent of his total profit.
Total profits. And that's the interesting thing, because the district court awarded the Samsung Corporation, awarded the Apple Corporation full profits of the entire Samsung Galaxy S4.
Right.
They awarded all of the profits.
Millions of dollars.
Hundreds of millions
in the case.
In fact, almost $1 billion was awarded to
billion?
Apple. Yes. Wow. Almost $1 billion was awarded to Samsung, or to Apple, for Samsung's infringement.
Yeah.
But Samsung says, whoa, hold up. Section 289 does not say, it's the total profits of the phone, of a multi-component phone. The iPhone or a Samsung phone has so many components. And Samsung argues that section does not say that, a single infringement of a particular part of the phone, which, I don't know if you know. Do you know what part of the phone was actually infringing for the design patent?
Yeah, that's kind of what I want to talk about, because, close to $1 billion, the total profit of this phone, which is very complex, and includes, thousands upon thousands of transistors within the phone, the cameras that are, make up the phone, just the chip manufacturing process of these computers that are so compact that they will fit in our pockets. There's all these components, but the design patent infringement was on the front face of the phone, that rounded corners.
It has certain aspect ratios, I think, right?
Yes, yeah.
The corners have certain aspect ratios with the curvature, and then I think it was the front face, the actual front face, but not the whole phone, correct?
Not the whole phone, just that front face the user interacts with, where the icons of the phone are on the phone, which of course was typical iPhone has those rounded corners.
And so the main thing was, Samsung says this is a multi-component phone, and the article of manufacture at this point is not, the total profits does not attribute to the whole phone. It's total profits that attribute from the result of the article of manufacture in this case, which is just the rounded corners.
Right.
And so that's the interesting thing that Samsung argues all the way up to the Supreme Court. It's Section 289 argues for article of manufacture for a specific design patent, rather than a design patent of a article manufacture on a multi-article
product.
Product, exactly. So,
which of course Apple is going to reject.
Yeah.
It's going to say no, because as you mentioned, Samsung feels like it's in this race to catch up with the iPhone, first released in 2008. Right?
Yes.
And so they're arguing, well, they're just copying our design, and that's really the question: is how many hours did Apple spend designing, which may seem simple to us, this front face with the rounded corners, or was it a stroke of genius? Regardless if it was a stroke of genius or they spent countless hours, how do you attribute that to Samsung's profits of this phone? And so Apple, of course, is going to say no.
And they would make hundreds of millions of dollars more based on winning this suit.
Right.
That's the main thing. Apple's incentive is, of course, to ensure that they can get the most money out of this lawsuit, because Samsung did get found guilty.
Well, and eliminate the market competition for Samsung as well.
Exactly.
And not have a phone.
And the interesting thing that this case really gets into is what is the article of manufacture, and how do we determine that?
Right.
So it's argued all the way up to the Supreme Court, and the petitioner, which is Samsung, argues that this multi-component phone, we can say that the article of manufacture not only is, the design patents that were found to be infringed upon,
right,
which is the rounded corners and the front face.
Infringement is not the issue.
Infringement is not the issue, exactly. Infringement has already been found.
Right.
But article of manufacture, what the total profits represent from that article, is at stake here.
Yeah.
And Samsung says we can, basically show that total profits should be from what consumers, basically will pay, and the total profits that are from the rounded corners or the front face of the phone.
Yeah, there's going to be factors that they have to prove, because you can say that, the article of manufacture does not apply to the total profits.
Yes.
But of course, the judges, as you know, asked, okay, well then what are your factors for determining that? It's like, Apple could have provided, consumer, surveys, evidence to say, no, we buy the iPhone because I like how it looks. I like these rounded corners. And the analogy that's always used in this case, of course, the Volkswagen Beetle, where it has that iconic shape of the car, and you say, okay, well, I'm going to buy this car because it has that iconic shape.
Yes.
There was no surveys that showed, are consumers buying the iPhone because it has that shape? Or you could have done a trace of profits, right? For the, manufacturing, this is how many hours of labor were put into designing this product. Of course, not the manufacturing, because that would be a utility patent, but designing this, and
the components that go in, the materials.
The percentage of the phone that makes up, and the total profit of the phone. So that's another way to track it.
Yes.
So I think those are some of the factors that Samsung says, could be used.
Exactly.
But Apple never presented those.
And that's the test that the petitioners, Samsung, want to say, this is how total profits should be found. And the judges are a little scared because Section 289 says total profits. The justices, I apologize. The justices, are saying there should be no such thing as this apportionment because the statute is very clear, total profits. And Samsung says, exactly, but total profits are from the design patent, the infringing article of manufacture.
That's right, because it says total profits, but it says total profits of the article of manufacture, in this case is not the whole phone.
And Samsung argues that this is not the whole phone, the article of manufacture. And Apple is arguing that the, almost the Beetle case, where consumers basically determined that this whole phone is the article of manufacture, and really that total profits for the entire phone should be attributed and awarded to Apple.
So now I think, we've explained, kind of the issues behind the case a lot, but I want to talk a little bit now how Samsung goes about convincing the Supreme Court to rule in their favor, because first, we've had the district and federal circuit courts rule in Apple's favor in regards to this. So
the interesting thing is the federal circuit courts say, well, Samsung, the rounded corners of the phone, the lifted bezel, those are not separate from the actual sold phone, the product.
Right.
So the total profits are what's at work here. And of course, Samsung again argues all the way up to the Supreme Court that this is not how Section 289 is meant to be interpreted.
Yeah, Apple's saying if you had sold this component, the front face, separately from the phone, you always sold it with the phone, then maybe we could determine the total profits of that. But it's always with the phone.
Yes, exactly. And Samsung argues, there are three kind of hypotheticals that give insight to this problem of article of manufacture.
Yeah.
And that's the Beetle, a car with a very distinctive look that consumers might specifically buy that car for.
Right.
And then the opposite would be a cup holder within the car.
Right.
A article of manufacture, but is pretty much a de minimis ruling where it doesn't actually infringe that much upon, a particular
the
design.
car is very complex. There's a lot of components.
There's a lot of components.
Are people buying this car for its cup holder, or does it have to do with fuel economy, the horsepower of the engine, how it looks, all of the other accessories?
Exactly, and that's the main thrust of Samsung's argument, which Apple, in all honesty, really did not have a good rebuttal to. In fact, the justices ruled unanimously in terms of for Samsung, saying that the article of manufacture could be a specific component of an article of a multi-article system or product, and that really shows the idea that
that's huge.
Whether it's the Beetle, whether it's the cup holders, these multi-component products, the total profits can be from a specific part. Now, again, it could be a substantial part. So for the Beetle, for example, Apple and Samsung both agree that the Beetle could represent would be a almost possible total profit awarded case. But it's how those profits are awarded, which is the question here. And Samsung will argue the Beetle exterior might represent 95% of why consumers buy it, and therefore somewhere around 95% of the profits, taking into account manufacturing,
all the labor that goes into designing.
Exactly.
All that. But the fact that the court rules in Samsung's favor in this case is a very, I would say, monumental decision in terms of precedents. Which, granted, still their ruling in Samsung's favor is consistent with prior cases and the wording of Section 289.
Yes.
But they do not ever mention the processes that should be used to determine the article of manufacture.
Yes.
Because that would require lots of tests and evidence that Samsung or Apple, neither of which brought forward for determining, but the justices decided that this case could be resolved without deciding what those processes are.
Yes, in fact, it was interesting because Samsung actually proposes, a 3-part test that the justices, particularly Justice Kennedy, really didn't feel adequately addressed the problem of article of manufacture. So the main thrust here is Section 289 shows, and I would argue relevantly shows, particularly now, relevantly shows that a multi-article product, an infringing design patent, really should be total profits of that article, specific article, rather than maybe the whole.
Even if it's sold with this product all the time.
Exactly.
Transistor.
And it really is topical now because the cutting edge tech that is being produced by a lot of companies, this is 2011 before the iPhone really has cemented itself as the. It really had cemented itself, but.
Now
We have tech companies, the big tech companies, and really a lot of cutting edge companies that these multi-article components in these
very multidisciplinary.
Yes, very multidisciplinary.
And so, how do you separate? Are you really going to take this, some electrical invention that's applied to a cutting edge optical technology and say no, this is the electrical invention, takes the total profits of my product,
And is that particularly fair? I would argue, and I think the court really kind of unanimously says in its decision, no, we are in a time now where components or products have so many articles of manufacture that it's pretty inconsistent and really not beneficial to our financial ecosystem to award total profits for a small sliver, which a lot of companies will try to do.
Obviously, in this case, as we mentioned, they're not going to, take the time to decide what those processes are for determining article of manufacture. But do you think that's something, in the near future down the line that needs to be decided on? Because as you just mentioned, technologies now are so multidisciplinary that this is a very influential case for our technology now. But we're going to need to develop a process now, because otherwise we're going to go through this whole case again.
Well, I don't know. I don't know about that, Logan. The reason I would say perhaps not is, and perhaps the reason why the court doesn't decide on a specific case or specific test cases currently is determining a one-way solution for an article leaves it might handcuff a lot of future cases. I think leaving it up to the jury,
like case by case basis.
Yeah, leaving it up to the jury to say, all right, we think this is the article, is basically it'll really be up to the jury. Now, there is the argument that there should be a test.
I think there are tests that you can't show for evidence, like you can provide consumer evidence, surveys, or you really show this is how many hours are attributed to. I think those are some of the already basic ways that you can show that, but it would be interesting, I think, if that process ever, if that ever develops out of this case, and a process is established for, if more of these cases come up. Because I think one thing that, might want to mention before we log off for tonight is just the fact, with these huge companies that sometimes are taking a monopoly. Like you mentioned with Apple over the iPhone market, they'll just file willy-nilly a bunch of design patents.
File a ton of design patents.
Their entire product. That way, any company that comes in and tries to make something similar, they say, aha, you infringed on this little component of my product. So, it might be very prevalent to decide on a process
to determine article.
Or, as you said, it is a very complex situation, so case-by-case basis.
Might or might not, and that's really a question that I think will be answered, particularly in the next, decade or so.
Yeah.
So,
Okay.
All right. Well,
I think the audience probably learned a lot about Samsung v. Apple and the design patent at issue. So thank you very much
thank
for
you,
coming on
Logan.
the
I
show.
had a wonderful time. It was really a great talk, and Patent Pulse is one of my favorite podcasts out there.
All right. Check back in with us next Sunday at 5 p.m. again. We are going to be discussing another patent infringement case with Sebastian Magri.
Yes,
Thank
sir.
you again for your expertise this evening.
Yes, thank you.
All right.